one matter for being spoken to tomorrow.
ಅದು
I will not skip all the charge sheets, my lords.
ಆಯ್ತು ಸರಿ, ನಂಗೆ ಸೈನ್ ಮಾಡಿಲ್ಲ ಅದೇನು ಇದೆ, ಚೇಂಬರ್ಲಿದೆ, ಕೊಡಿ
Please.
ಯಾಕೆ ಪ್ರಾಬ್ಲಮ್ ಇದೆಯಾ? ರಿಟ್ ಆಫ್ ಮ್ಯಾಂಡಮಸ್ 2:30ಗೆ ಬೇಕಾ? ಆಯ್ತು ಕೊಡಿ, 2:30 ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ, ಬಟ್ ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಮಾತ್ರ ಕೊಡಿ ಅಷ್ಟೇ.
This is one matter.
ಕೊಡಿ, ಬಟ್ ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ ಅಂದ್ರೆ ಆಮೇಲೆ ಏನು ಮಾಡಲ್ಲ, ಸುಮ್ಮನೆ ಬೇಜಾರಾಗುತ್ತೆ.
This is one matter which was posted in the last week, my lords. Lordships had directed to be posted on 17th. Somehow date is taken to be on 21st. 22nd is the last date for nomination. Cooperative society election. 19th, may I request at least?
ಯಾವತ್ತು?
Sorry, my lord.
You want it on 19th?
19th or 18th?
18th is tomorrow.
19th.
19th.
Please.
Serial number 41.
Wait, when it is called, then ಯಾವ್ದು reach is already 1 hour late. Yes.
My lords, may I submit, my lords?
Who is this?
My lords, it's from Bangalore bench, my lords. Memo for posting is already handed over to the court officer. Your lordship has already quashed for accused number 1.
Madam, video ಬರ್ತಲ್ಲ, ಎಲ್ಲ ದಿನ ಪ್ರಾಬ್ಲಮ್. ಎಲ್ಲಿ ಅವರು ಕಂಪ್ಯೂಟರ್? Ask him to come. ಏನ್ ಬೇಕು ಮೇಡಮ್?
My lord,
yes, madam, what do you want?
The matter is listed before the trial court on 21st for framing of charges. Your lordship has already quashed the proceedings as against accused number 1, my lords.
Yeah,
for accused number 2.
Who is this?
It's the doctor case.
Which doctor?
My lords, it's about the spa case against the doctor who was the orthopedic surgeon, my lords.
Anyway, I 20 level list it on 20th.
Obliged, my lords, grateful.
ಅದನ್ನ ಕರೆಕ್ಟ್ ಆಗಿ 20th ಕರೆಸಿ.
With my lord's kind permission, may I make a submission?
Yes, sir.
My lord, serial number 183, 188, 189, and 190. I'm requesting for an adjournment, my lords.
That we'll see, sir. I may not be reaching that also. We'll see.
That is why, my lords. No. But the reason why I'm making a mention, my lords, is on 19th there will be another identical matter which will be which was to be listed, my lords, on 19th.
190,
183, 188, and 190.
all tax matters, sir.
These are all, yes, my lords, demand based on income tax data which has already been passed.
When do you want it?
19th, my lords, I'll be there personally, my lords.
19th.
Obliged, my lords.
Thank you, sir. Yes. 170?
174.
Yes, call the case.
Serial number 1, fresh matters, VM Shilvan, VR Data, Girish Skulmani.
Please, your lordship, in this matter, the proceedings relating
yes, sir.
Proceedings relating to dismissal from service had been questioned.
No, I have heard you, sir.
Yeah.
Yodi, sir, I have heard you completely. Yes, sir. All yours.
Mallards, only our contention is that, Mallards, on even though the criminal case has been acquitted,
dates and events ಇದೆಯಾ ಕರೆಕ್ಟ್ ಆಗಿ ಇದರಲ್ಲಿ ಡಿಕ್ಟೇಟ್ ಮಾಡಕ್ dates and events ಕರೆಕ್ಟ್ ಆಗಿದೆಯಾ? ಯಾಕಂದ್ರೆ ಏನು ಇರಲ್ಲ.
there are some serious allegations, Mallards.
Serious allegations. Yes, sir.
Release of 500 tractors.
500 tractors. Correct.
The latest judgment on this aspect given on the 14th of February of this year, my colleague will hand it over, your lordship. In a similar situation where the original paragraph 45 onwards, your lordship. Last but one page. Where suppression, yeah, last but one page. With respect to his reinstatement and thing, this has been discussed. And your lordship,
that's all right. Yes, nothing new.
But in particular, what I have wanted to highlight to your lordship is that in this decision, the factum of suppression of the fact that
ಎಲ್ಲ ಸೆಪರೇಟ್ ಮಾಡಿ. ಈಗ ಕೊಡಿ. Yes, Girish.
My lords, in this case, my lords, the
Now,
annexure
I
is,
have passed an order saying that there was an inquiry earlier and he was exonerated. Which is that? Exoneration.
Right.
Yes, Montiora. Page.
Produced along with the IA.
ಯಾಕೆ ಮೇನ್
criminal case, my lords, CBI case,
It
my
was
lords.
CBI ಅಲ್ಲ, ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಎನ್ಕ್ವೈರಿ ಮುಂಚೆ ಆಗಿತ್ತಾ?
Please, my lords, he was
ಯಾವ್ದು?
convicted, he was suspended, my lords. Annexure,
Suspended is not a penalty, sir.
Dis-
What was
sorry,
the inquiry
dismissal.
conducted earlier?
produced along with the IA as at page number
84.
9.
That's page number 84.
ಯಾವ proceedings of departmental inquiry? Which departmental inquiry, sir? You had told
was
that
the-
earlier there, 1 minute, sir.
Yeah.
You had told that earlier there was a departmental inquiry and you were exonerated. This is second in line. Which is the first one?
That's the one, your lordship. We didn't
Page.
have that page number 9 along with IA, lordship.
Which IA is that? There are so many documents filed one after the other.
IA, list of documents with petition produced on
Dated,
2/2/24.
IA dated. ಇದರಲ್ಲಿ ಯಾವ page? 2nd February 24 ಅಲ್ಲಿ.
Page number 9 is the relevant one.
Complaint against front road so and so. ಅದೇನಾ ಇದು?
Please. And particularly on page 11, paragraph, the last paragraph. All the issues had been considered with respect to
Further, regional head visited so and so, verify the availability of various finance with bank, conducted, tractor borrowers are found and all tractors financed by the bank are in order. ಇದು ಯಾರು ಸರ್? ನಿಮ್ ಬ್ಯಾಂಕ್ ಅಲ್ಲ ಗಿರೀಶ್, ನಿಮ್ ಬ್ಯಾಂಕ್ ನವರೇ ಮಾಡಿ ಮತ್ತೆ ಹೆಂಗೆ huge? What is the submission of huge?
Well, it's huge, my lords, so there are,
Why did you do this? Why did you do this?
lords on the base.
ರವಿ, ಮೈಕ್ ಹಾಕೊಂಡಿದ್ದೀರಾ ಕರೆಕ್ಟ್ ಆಗಿ? ಕನೆಕ್ಟ್ ಆಗಿದೆ ನೋಡಿ, ಮಿಸ್ಟೇಕ್ಸ್ ಪರ್ಪರ್.
My lords, there was an inquiry, my lords, wherein he has been dismissed from service
ಕರೆಕ್ಟ್ ಸರ್.
on the basis of the allegations and irregularities being functioning as a manager, my lords.
What is this, sir? Complaint is unfounded and appears to have been made by some staff. Vested interest. All right. Him senior manager. ಏನ್ ಮಾಡಿದ್ರಿ ಇದಾದ್ಮೇಲೆ? Complaint is closed. Correct. Yes. Anything else?
Only I am just relying with the recent judgment, my lords, wherein even though the departmental CBI criminal case has been acquitted, that is not the basis for the
That is not.
setting aside them.
That is.
My lords, the general manager personal syndicate bank versus BSN Prasad. It's on
All right.
January, my lords, 2025. 21st January, wherein the court has held that, my lords, the Honorable Apex Court has held that even though the criminal case has been acquitted, that should not be a ground to quash the disciplinary proceedings order, my lords. That judgment I am relying, my lords.
I will consider that. ಅದಲ್ಲ ಏನು? Which paragraph of this judgment?
That's hand on, they are relevant, my lords, so is it.
ಕೊನೆಗೆ ಏನ್ ಮಾಡಿದ್ರಿ?
20th. Minor penalties.
ಮತ್ತೆ dismissal is harsh, converted to increment and back wages.
That's but I am relying only on that point, my lords, wherein the acquittal of the criminal case is not a ground to.
ಈಗ Herculean task is to dictate because ಏನು ಸಿಗಲ್ಲ ಇದರಲ್ಲಿ.
No, your lordship, if your lordship direct, I'll file a synopsis of the list of dates.
ಬೇಡ ಸರ್, 2012 ಮ್ಯಾಟ್ರು 13 years ಆಗೋಗಿದೆ ಆಗ್ಲೇ. Let me not waste because I will not leave it to another now.
The latest judgment I am only relying upon is
I-
suppression of
that- That we'll see, sir. Don't worry about the
Great,
latest
great,
judgment.
great for you. Great.
And my lords, only,
ಎಲ್ಲ sketchy synopsis ಇರುತ್ತೆ ಗೊತ್ತಾಗಲ್ಲ ಇಲ್ಲೇನು. The petitioner. How old are you now?
it's already.
59 ಅವಾಗ 13 ವರ್ಷ 72. The petitioner is before this court calling in question an order dated ಇದೇನು ರೆಡ್ಡಿಂಗ್ ಕಲಿದು ಅಮೆಂಡೆಡ್ ಪಿಟಿಷನ್ ಹಾಕಕ್ಕಾಗಿಲ್ವಾ?
Amended petition has been filed.
An order
98
dated
98/2007.
22/2/2008 by which the disciplinary authority imposes penalty of dismissal from service, and an order dated 5/4/2011 by which the appellate authority confirms the order of dismissal. Heard the learned senior counsel Kiran Jawli appearing for the petitioner and the learned counsel Girish Mulimani representing the respondent Union Bank of India.
My lords, respondent number 3.
Three matrana.
Because my lords, earlier the case was filed against respondent number 1 and 2. And thereafter, my lords, in the year 2024, the respondent number 3 has been implemented as respondent number 3.
Yalla Union Bank of India ne. So what?
But my lords, I am not having authorization in respect of respondent number 1 and 2.
To the chairman and managing director ಯಾಕೆ ಬೇಕು ನಿಮ್ಗೆ? ಅವ್ರು ಅಪೀಲೇಟ್ ಅಥಾರಿಟಿನಾ? ಅಪೀಲ್ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದಾರ? ಅವರೇ ಮಾಡಿರೋದ? ಫಾರ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಆಮೇಲೆ ಹೇಳ್ತೀನಿ ನೋಡಿ. Facts adumbrated are as follows. The petitioner ಹಳೆ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಸಿನಾಪ್ಸಿಸ್ ಹಾಕ್ಬೇಕು ಯಾವಾಗ್ಲೂ. ಏನ್ ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ? ಸುಮ್ನೆ ಕೋರ್ಟ್ಗೆಲ್ಲ ಬಿಟ್ಬಿಡೋದು. ಮತ್ತೆ ಪೆಂಡಿಂಗ್ ಇದೆ. You are part of the work you should do, sir. Yes. The petitioner ಈಗ ಯಾರು ಫಸ್ಟ್ ಬನ್ನಿ ಇಲ್ಲಿ ಸ್ವಲ್ಪ 15/6/2006 ಏನು
Suspension order. Superannuation order.
ಏನ್ ಆರ್ಡರ್ ಬರ್ದಿದ್ದೀರಾ? ಏನದು? ಸೂಪರ್ಯಾನೇಷನ್ ಆರ್ಡರಾ? ಇಟ್ಸ್ ಆಲ್ ರೈಟ್. ಸೂಪರ್ಯಾನೇಷನ್ ಆರ್ಡರ್ ಆರ್ ಸಸ್ಪೆನ್ಷನ್ ಆರ್ಡರ್ ಆಯ್ತು. ಮತ್ತೆ ಏನ್ ಬರ್ದಿರತ್ತೆ? ಫಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಏನಿದೆ? 15/6/2006. You don't know the difference between suspension and superannuation? Yeah. Why this lackadaisical attitude? Don't understand it all. ಏನ್ ಬೇಡ ಸರ್, ಅಲ್ಲಿ ಡಿಕ್ಟೇಟ್ ಅಂದ್ರೆ ಇಲ್ಲ. ಇನ್ನೊಂದಿನ ಇದನ್ನ ಹಾಕಿ ಲಿಸ್ಟ್ ಮಾಡಿ 60 ಪೇಜ್ ಪೆಟಿಷನ್ ಹಾಕಿದೀರಾ. ಏನು ನಾಟ್ ಬಿ ಲೈಕ್ ದಿಸ್. ಬರೆದ್ರೆ ಕರೆಕ್ಟ್ ಆಗಿ ಬರೆದ್ಕೊಡ್. ನೀವೇನ್ ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡಿದ್ರೆ 5 ನಿಮಿಷ ಡಿಕ್ಟೇಷನ್ ಮುಗಿಸ್ತೀನಿ. ಸರ್ಚಿಂಗ್ ಇಸ್ ದಿ ಪ್ರಾಬ್ಲಮ್ ಹಿಯರ್. The petitioner joins the services of the respondent bank initially as a clerk cum cashier on 12/9/1977. The averment in the petition is that owing to his blemishless record of service, the petitioner was promoted as a manager in middle management grade scale 2 in June 2002, and at the relevant point in time was working as a branch manager at the SS Front Road branch, Bijapur. Owing to certain omissions and commissions on the part of the petitioner, the respondent bank places the petitioner under suspension in terms of its order dated 15/6/2006. Later, on 10/7/2006, a charge sheet comes to be issued against the petitioner drawing certain articles of charge, alleging the petitioner to have indulged in misappropriation.
Misappropriation and irregularities ranging
indulged
to.
in irregularities in sanction of loan towards 500 tractors, which the bank alleges that certain amount of misappropriation has taken place. The petitioner then, the petitioner then on 16/8/2006 replies to the said notice. After ಏನಿದು ಇನ್ಕ್ವೈರಿ ಮಾಡಲೇ ಇಲ್ವಾ? ಎಸ್ ಒಂಟಿ ಮಾಡಲೇ ಇಲ್ವಾ? In terms of the regulations, an inquiry officer was appointed to conduct departmental inquiry against the petitioner. The result of the departmental inquiry was the inquiry officer holds the petitioner guilty of the offences. Based upon the report of the inquiry officer, the petitioner was imposed a penalty of dismissal from service on 9/8/2007, against which the petitioner prefers an appeal, and the appeal comes to be rejected by the appellate authority on 26/2/2008. A review petition preferred thereon on 15/12/2008 also comes to be rejected by an order dated 23/1. ಏನಿದು?
No orders.
The review petition is said to be pending consideration at the hands of the reviewing authority. The orders of dismissal from service has driven the petitioner to this court in the subject petition. The learned senior counsel, Kiran Jawli, appearing for the petitioner, would take this court through the documents appended to the petition and several proceedings that have happened in the aftermath of the imposition of penalty of dismissal from service. The learned senior counsel would contend that when the complaint was received, an inquiry or investigation was directed to be conducted by an officer of the bank. He has completely exonerated the petitioner. On the same circumstance, a criminal case was also registered. The criminal case ended in honorable acquittal of the petitioner. The twin circumstance is now projected, contending that the present disciplinary proceedings is after the bank finding no fault against the petitioner, as also no fault of the petitioner, as also the fact that the petitioner has now been honorably acquitted by the honorably acquitted by the concerned court. CBI. Concerned court hyphen the court by the CBI court. He would seek quashment of the orders impugned and all consequential benefits to flow to the hands of the petitioner. The learned counsel Girish Mulimani, appearing for the respondent, would vehemently refute the submission of the learned senior counsel, contending that the charges against the petitioner were serious, as it was grant of indiscriminate loan without adequate security to 500 tractors. The loan could not be recovered. Misappropriation also was the allegation against the petitioner. In such cases, whether there has been acquittal or otherwise would not have any bearing upon the departmental inquiry conducted in terms of the regulations, is his submission. He would not dispute the fact that earlier complaint was looked into and he was completely exonerated, but that does not mean that departmental inquiry should not be conducted, or the conduct of departmental inquiry can be found fault with on the said score. He would seek to place reliance upon the judgment of the apex court in the case of Syndicate Bank versus BSN Prasad to buttress his submission that mere acquittal in a criminal case would not inure to the benefit of an employee to seek the quashment of the orders that are passed pursuant to a departmental inquiry. I have given my anxious consideration to submissions made by the respective learned counsel. The afore narrated facts, link in the chain of events and the dates are not in dispute. It would suffice if the issue would be narrated from the date on which the petitioner is placed under suspension. The suspension comes about owing to several irregularities of the petitioner, irregularities in the conduct of loans of the petitioner when he was in Navalgund branch as its branch manager. The order of suspension is in great detail. The petitioner replies to the, sorry, where is the order of suspension, sir? Oh, the dismissal order. In great detail, beda. The petitioner then is, oh, adello ittu torsalappa. After the, long before the petitioner being placed under suspension on 5/6/2006, when the complaint emerged of the acts of the petitioner in the branch, an investigation was directed to be conducted. The result of the investigation, which was conducted at the hands of the senior manager therein, is as follows. Page 9 to 12. Upon analysis of the entire spectrum of the allegations against the petitioner, the complaint was said to be unfounded and appeared to have been made by some staff or public mischievously with vested interest against the petitioner. This finding has become final, is an admitted fact. On the same facts, the order of suspension comes about 2 years thereafter, and a charge sheet is drawn against the petitioner. The drawing of the charge sheet results in appointment of an inquiry officer to conduct departmental inquiry against the petitioner. The findings of the, where is the order of the inquiry officer?
Of charge.
Jain report, additional document.
N reporter?
VK Jain, he is the General Manager, Vigilance Department.
Sir, inquiry officer report
ಇದು oh, please.
ಸುಮ್ಮನೆ ಯಾರ್ಯಾರ್ದು ಹೇಳ್ಬೇಡಿ. ಅದೇ ಎಲ್ಲ ನಾವೇ ಹುಡುಕೋಬೇಕಲ್ಲ, ಹುಡುಕ್ತೇವೆ ಬಿಡಿ. ಇದ್ರೆ ಹುಡುಕ್ಬೋದು, ಇಲ್ಲೇ ಇರೋದ್ನೆಲ್ಲ ಹುಡುಕೋದು.
Articles of charge.
ಯಾಕಂದ್ರೆ ಒಂದ್ ಕಡೆ ಇರಲ್ವಲ್ಲ ಎಲ್ಲೂ. If this is the assistance I get, old matters ಅಷ್ಟೇನೆ.
A compilation I had directed him to provide.
ಯಾಕೆ ಒಂದೇ ಸರಿ ಎಲ್ಲ ಒಂದೇ ಕಡೆ ಹಾಕಕ್ಕೇನು?
ಇಲ್ಲ, ಅದು it was
ಸುಮ್ಮನೆ
drafted.
ಹಿಂಗ್ ಆಗ್ತಾ ಇರೋದು ಏನೋ ಒಂದು.
It was draft. Actually. Next year. Next year.
ನನಗೇನಿಲ್ಲ, ಬೇರೆ ಮ್ಯಾಟರ್ಗಳು ಹೇಳಪ್ಪ ಆಗುತ್ತೆ. ಕಾಂಟ್ ಹೆಲ್ಪ್.
Has been filed along with the additional documents.
ಇದನ್ನ ಸಾಯಂಕಾಲದವ್ರು ಡಿಕ್ಟೇಟ್ ಮಾಡ್ತೀನಿ, ತೊಂದರೆ ಇಲ್ಲ.
G. Page number 80, next year. G.
Page number ಹೇಳಿ.
Page number 80.
ಸ್ವಲ್ಪ ಸುಮ್ಮನೆ ಇರಿ ಸರ್. The inquiry officer holds the petitioner guilty of the allegations by the following order. Page 165. After the report of the inquiry officer, the disciplinary authority issues a second show cause notice. The second show cause notice is replied to by the petitioner. Notwithstanding the same, the petitioner is imposed penalty of dismissal from service by an order of the disciplinary authority dated 9th August 2007. The order reads as follows. The allegation against the petitioner was, the finding against the petitioner in the disciplinary authority's order was failure to take all steps to ensure and protect the interests of the bank, not conducting due diligence, performing duties with dishonesty and acting otherwise than the best judgment in the performance of his official duties. There is no allegation against the petitioner that he has misappropriated amounts. The account being turned into NPA by poor monitoring by the petitioner is what is projected to be the reason for dismissal from service. Next paragraph. Certain analogous proceedings take place. The factum of the petitioner getting involved in the aforesaid act of grant of loan, which according to the bank was indiscriminate, resulted in criminal proceedings being initiated. Therefore, the two proceedings emerge from one solitary fact of the petitioner being petitioner granting loans and those loans becoming sticky. The concerned court, i.e. the CBI court which tried the case against the petitioner, acquits the petitioner of acquittal order.
Special CC 10 of 2013.
Acquits the petitioner in terms of its order dated 28 March 2024. The order of acquittal, the reasons rendered to acquit the petitioner, as could be gathered from the order of acquittal, is as follows. Page 70, para 71 in the till the end. The finding is that the prosecution has failed to prove any of the charges, and there was no role of the accused persons in the entire charges from the evidence of all the material witnesses. Therefore, it is a case where the court does not render its acquittal on benefit of doubt. The court clearly holds that the petitioner has been acquitted as the prosecution had failed to prove the guilt beyond all reasonable doubt, and there was no evidence to prove any charge against the petitioner. The circumstance now would be whether the order in the departmental inquiry would get vitiated on account of the honorable acquittal of the petitioner. The learned counsel for the respondent seeks to places heavy reliance upon the judgment rendered by the Apex Court on 21st January 2025 in the case of Prasad Supra to contend that the proceedings conducted in a departmental inquiry cannot have any bearing even if the employee has been acquitted in the criminal case. The findings of the Apex Court are as follows. Para 22 to 24. The Apex Court, though observes as aforesaid, grants relief to the employee, holding that the punishment imposed upon the employee was disproportionate and converts dismissal from service into a minor penalty as obtaining under the regulations. Therefore, the said judgment would not have any bearing upon the issue in the list. What needs to be noticed in the next paragraph? What needs to be noticed in the case at hand is when the complaint emerged, an inquiry or investigation was conducted. The investigation completely exonerated the petitioner. Notwithstanding the same, owing to the direction or dictate of the Vigilance Commission, a departmental inquiry was directed to be conducted. So as the registration of the criminal case. With these facts, what would become applicable is the judgment of the Apex Court in the case of Ramlal versus so and so, reported in 2024, 1 SEC, page 175, the court paragraph 25 to 32. The Apex Court considers the entire spectrum of the law and holds that when an employee is honorably acquitted in a criminal case, the findings in the departmental inquiry will have to give way notwithstanding the fact that the acquittal comes about at a later point in time, as criminal cases would take a long time to get disposed. The finding in the case at hand is completely in favor of the petitioner in the criminal case so registered, as it is an honorable acquittal. And the circumstance that the petitioner was already inquired into on the same complaint and completely exonerated would inure to the benefit of the petitioner. Next part. In identical circumstances, a division bench of this court, in the case of Ijaz Hussain versus so-and-so, ILR 2020 Karnataka 4251, has held as follows, para 2526. The division bench, again considering the entire spectrum of the law which prevailed then, holds that the employee the penalty imposed on the departmental side will have to be obliterated if it was based upon the same set of facts, same evidence in the criminal case. In the case at hand, it is not in dispute that both the departmental inquiry and the criminal case sprang from the same set of facts. The same evidence was before both the authorities, both departmentally and in the criminal case. The evidence or the witnesses examined were almost common. If this be the case, the judgment relied on in the case of BSN Prasad would not become applicable to the facts of the case, as it is distinguishable without much ado, ADO, without much ado. In that light, the petitioner now becomes entitled to the relief that he has sought for, i.e. the quashment of the proceedings on the quashment of the order of penalty imposed upon him. The learned senior counsel has placed reliance upon the judgment of the so-and-so to buttress his submission with regard to grant of back wages when such obliteration would happen. There can be no qualm about the principle so laid down by the apex court. But in the case at hand, the petitioner has retired.
July 2013.
July 2013.
13.
In July, on 31st July 2013, on attaining the age of superannuation, but dismissal was earlier.
Early 2000.
The petitioner in the case at hand had been dismissed in the year 2007. If he were to be in service, he would have retired on attaining the age of superannuation on 31st July 2013. His terminal benefits are not settled. Therefore, the finding of the apex court in the aforesaid judgment would become applicable to the facts of the case at hand. Just back wages. And therefore, the aforesaid reasons the following order. Pension in Kotralala. So-and-so quashed. The petitioner shall become entitled to all consequential benefits that would flow from quashment of the order, including back wages, 100% better.
Because Mullards, and another reason is that Mullards, since from 2013 till 24, the matter has not seen the light itself. Mullards, only on the Mullards. Mullards, I'm not.
So, therefore, the petitioner shall become entitled to 50% of the back wages.
75.
No, sir. 50% of the back wages from 2007 to 2013, and all terminal benefits from 2013. All terminal benefits to be calculated from the date of superannuation, taking his service as complete as if the order of dismissal was never in existence. Yes.
Grateful.
My apology, Lordship.
ಎಲ್ಲರಿಗೂ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. If you give me some synopsis, ನೀವು ಅಸಿಸ್ಟ್ ಮಾಡಿಬಿಟ್ರೆ ಎಲ್ಲ ಖಾಲಿ ಮಾಡಕ್ ತೊಂದರೆ ಇಲ್ಲ. ನಾನೇನ್ ನೋಡ್ಕೊಂಡು ಮಾಡೋದು ಅಷ್ಟ ಆಗುತ್ತೆ.
It was drafted by someone presented and
Synopsis ಕೊಡಕ್ಕೆ.
True, it's my mistake. It's my mistake.
13 ವರ್ಷದಿಂದ
ಇಲ್ಲ, in fact, ಇವತ್ತು ರೆಡಿ ಇತ್ತು, ಬೇರೆ ಕಂಪೈಲೇಷನ್ ರೆಡಿ ಇತ್ತು, ಅದು ಕೊಟ್ರೆ ಮತ್ತೆ ಡೇಟ್ ತೋತಾರೆ ಕೊಡ್ಲಿಲ್ಲ.
13 ವರ್ಷದಿಂದ ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂದ್ರೆ
ಜಂಬಲ್ಡ್
ನಾಟ್ ಕರೆಕ್ಟ್.
True.
ಅದಕ್ಕೆ ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಅಂತ ಹಾಕ್ಸಿದ್ದೇನೆ ಅಂತ.
ಹೌದು.
ಬಿಕಾಸ್ ಇನ್ ಕೆಳಗಡೆ ಫೈನಲ್ ಇಯರಿಂಗ್ ಹೋದ್ರೆ ಎಲ್ಲೋ ಹೋಗ್ಬಿಡುತ್ತದೆ. ಇನ್ನು 5 ವರ್ಷ ಬಿಟ್ಟು ಬಂದ್ರೆ ಮತ್ತೆ 50% ಬ್ಯಾಕ್ ವೇಜಸ್, ಮತ್ತೆ ಇದು ಯಾರು ತೊಂದರೆ ಆಗುತ್ತೆ ಅಲ್ಲ. ಇದು ಮೇಲೆ ಫಿಲಿಯನ್ ಹಾಕ್ತಾರ ಅವರು ಬೇರೆ ಮಾತು, ಬಟ್ ಅವಾಗ ಆಗ್ಲಿ.
230.
Bill number 2, Santosh B. Malgowda.
Filing the affidavit, my lords. That the respondent number.
Anganwadi,
Appointment.
which resident?
Village, Rebadnur village.
Yes, sir, Santosh.
ಇಲ್ಲ. Annexure M may kindly be seen. That is a fact.
ಇವಾಗ ಇನ್ಸ್ಪೆಕ್ಷನ್ ಮಾಡಿದೀನಿ. Now 12 years afterwards, I will not caution Anganwadi.
In fact, on
ಯಾರೋ
that
ಮಗು
day,
ನೋಡ್ಕೊಂತ ಇರ್ತಾರೆ ಬಿಡಿ.
on that given day, my lords, she was not the resident of my lords Hirebudnu. She was staying in her grandma's place.
What is the report, sir?
Please.
ನೋಡಿದ್ರಾ?
ಇಲ್ಲ, ಈಗ ಕೊಟ್ಟಿದ್ದಾರೆ. not seen. She was staying in her grandma's place for 10 years.
Grandma's place.
Yes, and that, my lords, that document she presented before, my lords, the authority at the time of
ಒಂದು
application.
ನಿಮಿಷ. Now, it is supported by an affidavit of the ತಹಸೀಲ್ದಾರ್. ತಹಸೀಲ್ದಾರ್ ಯಾರಿದು? ಯಾರು affidavit ಹಾಕಿದ್ದೀರಾ?
CDPO, my lords.
CDPO, all right. Is a responsible officer filing an affidavit, all right? And
One
it is
annexure M, my lord. Must the then
ವಾಸ ಸ್ಥಳದ ಪಂಚನಾಮ ದೃಢೀಕರಣ ವರದಿ.
ಅಲ್ಲ, ಅವಾಗ ಏನಾಗಿದೆ ಅಂದ್ರೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2, my lords, the deputy director of my lords, child and women welfare, he wrote a letter to the Tashildar regarding he had a doubt, my lords, with regard to residential proof of my lords
Annexure M
respondent.
ಏನು?
Annexure M ತಗೋ, just hang a note.
Page.
Annexure M. Lordship, kindly turn.
ಏನಿದೆ?
Lordship, the third line for a moment. ತಮ್ಮ ಪತ್ರದಲ್ಲಿ ಈ ಬಗ್ಗೆ ನಿಖರವಾದ ಮಾಹಿತಿ ಲಭ್ಯವಾಗಿರುವುದಿಲ್ಲ. ಹಿರೇಬುದ್ನೂರ್ ಸದರಿ ಕುಮಾರಿ ರೇಣುಕಾ ಇರಿಗಾರ್, ದಟ್ ಇಸ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 4. ಇವರು ಅಜ್ಜಿಯ ಮನೆಯಲ್ಲಿ 1ನೇ ತರಗತಿಯಿಂದ 10ನೇ ತರಗತಿವರೆಗೆ ವಿದ್ಯಾಭ್ಯಾಸ ಮಾಡಿದುರಾಗಿ ತಮ್ಮ ಪತ್ರದಲ್ಲಿ ತಿಳಿಸಿದ್ದು, ವಿದ್ಯಾಭ್ಯಾಸ ಸಲುವಾಗಿ ಸದರಿ ಕುಮಾರಿ ರೇಣುಕಾ ಇವರು ಅಜ್ಜಿಯ ಮನೆಯಲ್ಲಿ ಇರುವುದು ತಮ್ಮ ಪತ್ರದಿಂದ ತಿಳಿದು ಬರುತ್ತದೆ. ಕಾರಣ ಅಜ್ಜಿಯು ದತ್ತಕ್ಕೆ ತಗೊಂಡಿದ್ದಾರೋ ಅಥವಾ ಅವಳು ಅಜ್ಜಿಯ ಆಸ್ತಿಗೆ ಹಕ್ಕದಾರಳೋ ಎಂಬುದನ್ನು ಸ್ಪಷ್ಟೀಕರಿಸಿಲ್ಲ. ಆದ್ದರಿಂದ ಈಕೆಯ ತಂದೆ ಅವಳ ಮೂಲ ಪೋಷಕರು ಅಥವಾ ಅಜ್ಜಿಯ ಮೂಲ ಪೋಷಕರು ಎಂಬುದರ ಕುರಿತು ಸ್ಪಷ್ಟತೆ ಇರುವುದಿಲ್ಲ. ತಂದೆ ಆಸ್ತಿಯಲ್ಲಿ ಸದರಿ ರೇಣುಕಾ ಇವಳಿಗೆ ಪಾಲು ಇರುವುದು ಅಥವಾ ಎಂಬುದರ ಬಗ್ಗೆ ಸ್ಪಷ್ಟೀಕರಣ ಕುಮಾರಿ ಸ್ವಯಂಸು. She has given the application, my lords, and the respondent number 2 doubted her, my lords, the certificate, and here wrote, my lords, the letter to the Tashildar. And this, my lords, on this there was no order, my lords, passed by the Tashildar. It was, my lords, in the year, my lords, 2013 itself, the moment when she applied for the post with some documents, and when the doubt arose to the respondent number 2, who is the appointing authority, and a letter was forwarded to the Tashildar during that point of time. Now they come up, my lords, with this report.
Correct. This is very doubt, ಅದು confirmation.
ಅಲ್ಲ, ಬಟ್ ಇಲ್ಲಿ ಅವಳು ಅವಾಗ at the time of application, my lords, and she has not presented, my lords, the voter card. That was a prerequisite, my lords, in condition number 2 in the application.
ಇಲ್ಲಲ್ಲ, ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಇಲ್ವಲ್ಲ?
ಇಲ್ಲ, it's final disposal, not for final.
ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಇಲ್ವಲ್ಲ ಇದರಲ್ಲಿ?
ಇಲ್ಲ,
ಇದು 2013
13 madam.
ಅದಕ್ಕೆ 12 years ಇಂದ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಇಲ್ವಲ್ಲ? ಯಾರೋ ಮಗು ನೋಡ್ಕೊಂತ ಇದ್ದಾರೆ ಬಿಡಿ.
ಇಲ್ಲ, now this lady is also the second rank in the list, and in the temporary list, my lords, she was having second rank just because, my lords, she was not a resident of Hirebudnu. Because the petitioner was
who's not the resident?
She was in fact not resident, my lords, at that point of time.
Why was your candidature denied?
Because I was having less percentage, my lords, that is second rank. I was in the second rank. That is
She was first rank.
She was 65% first rank. So far as residential proof
makes your case more difficult.
Residential proof ಏನು ಇರಲಿಲ್ಲ.
No, that is why I call for inspection. I cause an inspection in these 12 years ಆದ್ಮೇಲೆ ಏನು ಅಂತ. ಇಲ್ಲಿ ಏನೋ ಇರುತ್ತೆ, nothing will be there. Now with this I can't doubt. ಮತ್ತೆ ಇನ್ನೊಂದು ಇನ್ಸ್ಪೆಕ್ಷನ್, ಮತ್ತೆ ಇನ್ನೊಂದು
ಇಲ್ಲ, ಅದನ್ನ ಹೇಳ್ತಾ ಇಲ್ಲ. ಬಟ್ ಅವಾಗ ಅವ್ರು ಅಪ್ಲೈ ಮಾಡಿದ್ದು ಆ ತರ ಮಾಡಿಲ್ಲಲ್ಲ. ಸೊ ಅದನ್ನೇ ನಾನು ಹೈಲೈಟ್ ಮಾಡ್ತೀನಿ.
Now there should be an end to this, ಅಲ್ವಾ ಸಂತೋಷ್?
Any vacant post, if they are there,
ಮಾಡೇ ಮಾಡ್ತಾರೆ. How old are you now?
Lords, she is now married, and she is depending upon this. She is in fact waiting for this post from almost 10 years.
You should not wait, sir.
At least on liberty kotre, any vacant post nearby, my lord, she will apply.
We'll see. No problem. I will answer this and also observe.
Please.
The petitioner record ಆಗ್ತಾ ಇದೆಯಾ? Record ಆಗ್ತಾ ಇದೆ ತಾನೆ? ಸರಿ ಇದೆಯಾ ಮೈಕ್? The petitioner is before this court calling in question an order of appointment of the third respondent dated 30/9/2013 as Anganwadi worker 2, which Anganwadi?
1 second. Before your lordship, the report itself, it says she was brought up by her grandmother, and my lords, and she has studied her primary education anta avare ಹೇಳ್ತಾರೆ. It is not that she is resident of that village.
ನೋಡ್ಬೇಕು ಅಂದ್ರೆ ನೋಡಿ ಹೇಳಿ.
ದಯಮಾಡಿ ತಾವು ಅದನ್ನ just
page 20, page 20, my lords.
Yes,
ನೋಡ್ಬಿಟ್ಟು ಹೇಳಿ.
just now I read, my lord, the same report has come. She is not the resident.
No.
Great.
Ready again, SC Booty?
Hearing for the respondent, filing the my lord seniority list.
ಸೀನಿಯಾರಿಟಿ ಲಿಸ್ಟ್ ಎಲ್ಲ ಕೇಳಿದ್ದೆ ನಾನು.
Artisan.
IB ಸುಂಕದ್ ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ ಆರ್ಟಿಸಾನ್ ಅಂತ,
Yes.
ಅವ್ರದ್ದು ಕೊಡಿ ಡೀಟೇಲ್ಸ್.
Please.
ಕೊಡಿ.
My lord, the IB Sunkad is, my lord, senior than the petitioner
Where?
for
Which?
6 months.
By 6 months. Date of
6
appointment.
years.
Date of appointment, both IB Sunkad and petitioner.
I may permitted to synopsis.
Appointed on, my lord, 13/11/1981.
One ನಿಮಿಷ.
Petitioner appointed on 14/11/1981.
ಸುಂಕದ್ 13/11.
Please.
ಒಂದಿನ ಮುಂಚೆನ.
ಒಂದಿನ ಮುಂಚೆ.
Same cadre.
Same cadre.
All right. Same selection.
Please.
That's all right.
Helper ಗೆ petitioner was promoted on 14/11/1987. Sunkad was promoted as helper A on 8/12/1989. 24/10/1989 ಗೆ assistant artisan the petitioner was promoted.
92.
Please. On 10/1/1997 Sunkad was further promoted to the post of artisan. The petitioner has not given it the further posting.
Lord,
Now, my
kindly
lord,
see
As simple as that.
seniority list, my lord, after, my lord,
ಯಾವ seniority list, sir?
seniority list, my lord,
On-
prepared by the,
Ah.
my lord, the respondent.
Don't rely on BK Pavitra seniority list, sir.
Yes.
Never do that. BK Pavitra 1 ಆದ್ಮೇಲೆ 2 ಇಂದ change ಮಾಡಿ 2 ಆದ್ಮೇಲೆ ಜರ್ನಲ್ ಸಿಂಗಲ್ ವಾಪಸ್ 1 ಗೆ ಬಂದಿದ್ದೀರಾ. So don't do all that.
ಅಲ್ಲ, 6 years.
Don't project BK Pavitra and try to obfuscate the issue. I will not get obfuscated.
My lord, he get promotion on, my lord, 21/11/1995 as assistant
With
artisan.
retrospective effect ಕೊಟ್ಟಿದ್ದೆಲ್ಲ ಹೋಯ್ತು. See, BK Pavitra 1 ನಲ್ಲಿ the seniority, the principle of catch up was said to be wrong and whoever was granted promotion was directed to be reverted. BK Pavitra 2 saved it. Jarnail Singh 3, 3 judge bench said BK Pavitra 2 is wrong. ನಾವು ಈಗ BK Pavitra 1 ಕೊಟ್ಬಿಟ್ಟು ನನಗೆ ಈ ತರ ಮಾಡಿದೀವಿ ಅಂದ್ರೆ ಆಗಲ್ಲ. You can tell it to the other, to me you can't.
Not like that, my lord. The, whatever the, my lord, they have, my lord, furnished to me, that has been placed before this honorable court. And also, my lord, as,
ಬಗ್ಗೆ ಹೇಳ್ತಲ್ಲ ಸರ್ ನಿಮ್ಮ client.
my lord, as per the, my lord, the letter, my lord, he is, my lord, 6 years, my lord, junior than the, my lord, the IB Sunkad.
ಯಾರು?
Petitioner, sorry.
ಹೆಂಗೆ ಸರ್?
My lord, assistant artisan, my lord, he has, my lord, getting assistant.
ಆರ್ಟಿಸನ್ ಆಗಿದ್ದು ಯಾವತ್ತು ಸರ್?
My lord, petitioner, my lord, 21/11/1995.
ಯಾರು?
Out, petitioner, my lord,
ಅಸಿಸ್ಟೆಂಟ್ ಆರ್ಟಿಸನ್ ಆಗಿದ್ದ
assistant artisan ಆಗಿದ್ದು.
1995.
1995. But, my lord, IB Sunkad, my lord, 24/10/1989
ಏನಾಗಿದ್ದು?
as assistant artisan, my lord.
That is, my lord, pursuant to BK Pavitra. They have filed along with memo, my lord. Yes, they have revised.
ಎನಿಥಿಂಗ್ ಎಲ್ಸ್? ಅವತ್ತಿನ ಡೇಟ್ಗೆ ಆಗ್ಲಿಲ್ಲ ಅದು.
ಇಲ್ಲ.
BK Pavitra
2019
ಆಗಿದ್ದಷ್ಟೇ.
Yes.
These are the dates of appointment, no doubt about it.
Please.
ಆಮೇಲೆ 23/9/1992 you gave it with retrospective effect to IB Sunkad. IB Sunkad is SC na?
Please.
Huh?
Please.
Yes, sir.
And also, my lord, they have challenged the, my lord, endorsement. My lord, the endorsement, my lord, they have clearly stated that, my lord, annexure, my lord,
Annexure D, page number 36.
2019 ತೋರಿಸ್ತಾ ಇದ್ದೀರಾ? ಇದಾದ್ಮೇಲೆ ಮತ್ತೆ ರೀಡು ಮಾಡ್ಲಿಲ್ವಾ ನೀವು? BK Pavitra 3 ಅಂತ ಇಲ್ಲ, ಇಟ್ ಇಸ್ ಜರ್ನೈಲ್ ಸಿಂಗ್. ಎಲ್ಲಿ ಜಡ್ಮೆಂಟ್ ಇದೆ?
I'm sorry, my lord.
ಹೆಂಗ್
Sir.
ಡಿಸ್ಪೋಸ್ ಮಾಡೋದು?
But, my
Can't
lord,
just
they have,
walk in, sir. You should do your
Please.
homework.
but they have produced the assistant artisan seniority list, not the artisan seniority list, my lord.
Yes. Yes, sir. Shana? The petitioner is before this court calling in question an endorsement dated 18/2/2012 by which the claim of the petitioner to be promoted to the cadre of artisan from the cadre of assistant artisan as given to one of his colleagues, IB Sunkad, is called in question. A consequent direction by issuance of a writ in the nature of mandamus is sought to grant promotion as artisan from the date on which IB Sunkad was granted promotion. Heard so and so. Facts in brief germane are as follows. The petitioner is appointed as an artisan, appointed as helper B
Please.
in the respondent corporation pursuant to a recruitment process. So is one IB Sunkad. Both of them get appointed pursuant to the same process. IB Sunkad joins service on 13/11/1981 and the petitioner the next day on 14/11/1981. The petitioner is then promoted owing to his seniority as helper A on 14/11/1987. IB Sunkad is promoted as helper A on 8/12/1989, 2 years after the promotion of the petitioner. The petitioner is further promoted to the post of assistant artisan on 24/10/1989, while IB Sunkad gets promoted as an assistant artisan on 20th March 1992. On 10/1/1997, 1997, IB Sunkad was further promoted to the post of artisan and was further promoted as chief artisan with effect from 4/3/2011. The petitioner thus retires from service as an assistant artisan and never gets to reach the cadre of artisan as was granted to his junior, i.e. IB Sunkad. It is therefore the petitioner then represents that he be promoted to the cadre of artisan as was given artisan and further cadres.
One submission. My lord, in the endorsement also, my lord, he is, my lord, his serial number is, my lord, prior to that, my lord, this seniority, preparing seniority list. My lord, IB Sunkad is at this serial number 15, but my lord, the petitioner serial number is on 31, my lord. As per the, my lord, the.
Why is that?
My lord, he is the petitioner is, my lord, junior than the IB Sunkad.
ಈಗ helper A ಇಂದ helper B ಹೆಂಗ್ ಹೋಗಿದ್ದು? helper B ಇಂದ helper A ಗೆ 2 years ಮುಂಚೆ ಪ್ರಮೋಟ್ ಆಗಿದಾರೋ ಇಲ್ವೇ? Which seniority are you referring to?
My lord, as per the, my lord, the endorsement, my lord, the.
Endorsement, sir, which seniority are you referring to? ಇವರು ಹಾಕಿಲ್ಲ, ನೀವು ಹಾಕಿಲ್ಲ.
There is no records, my lord, that's why.
Why no records?
Old matter, my lord.
ಇದಕ್ಕೆ ಓಲ್ಡ್ ಮ್ಯಾಟರ್ಸ್ ಪೆಂಡಿಂಗ್ ಇರೋದು ಸರ್ ಇಲ್ಲಿ. ಎಲ್ಲ ಹಿಂಗಾಗೆ ಪೆಂಡಿಂಗ್ ಇರೋದು. 13 ವರ್ಷ, 14 ವರ್ಷ, 15 ವರ್ಷ ಪೆಂಡಿಂಗ್ ಇದೆ. ಎಲ್ಲಿ ಸೀನಿಯಾರಿಟಿ ಲಿಸ್ಟ್ ಯಾವ್ದಾರು ಇದೆಯಾ?
ಇಲ್ಲ, ನಮ್ ಕಡೆ
ನಿಮ್ಗೆ ಕ್ಲೈಂಟ್ ಕಾಂಟ್ಯಾಕ್ಟೇ ಇಲ್ಲ.
ಕಾಂಟ್ಯಾಕ್ಟ್ ಇಲ್ಲ. He's bedridden.
Bedridden. Yes. So what should I do?
I'm sorry, Lord.
He's bedridden and no information. We'll dismiss it straight away. Dismissal is easy. I will hold that he is senior and close it now.
But my lord, sir.
Unless you produce something. Why is that seniority list 31 ಯಾಕಾಯ್ತದ? ಯಾಕಾಯ್ತು?
I will get the seniority list and produce, my lord.
Case also will become bedridden now. ಏನಾಗಲ್ಲ. ಇದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ ನೋಡಿ.
2019 after BK Pavitra, my lord.
ಇಲ್ಲಿದೆ, where which seniority list? Where are the other cases? Sir, you can't run the court only on mandamus consideration cases. Substantial cases have to be considered.
Please.
For that, something should come from your side. Yeah, ಏನಾರು ಮಾಡ್ಕೊಳ್ಳಿ. Let's tomorrow.
Please.
I'll see what you will get. Go through this.
Please.
See, get the judgments.
Please.
BK Pavitra 1, rendered on 9/2/2017. BK Pavitra 2, rendered on 10/5/2019. After that, government has issued government order 23/6/2019. ಈ government order ಏನ್ ಮಾಡಬೇಕು ಅಂತ ಇದೆ. ಆಮೇಲೆ there was an act was promulgated earlier which forms the part into BK Pavitra 2. Then BK Pavitra 3, it was referred to a larger bench. ಜಸ್ಟಿಸ್ ನಾಗೇಶ್ವರ ಅವರು ಜರ್ನೈಲ್ ಸಿಂಗ್ 3 ಅಂತ ಸಿಗುತ್ತೆ ಸರ್ಚ್. ಅದ್ರಲ್ಲಿ ವಾಟ್ ಅಂಡು ಮಾಡ್ಬೇಕು ಅಂತ ಇದೆ. ನಿಮಗೆಲ್ಲ ತರ್ಬೇಕು. ಎಸ್, ನಾಳೆ ನೋಡೋಣ ನಾಳೆಗೆ ಏನ್ ತರ್ತೀರಾ ಅಂತ.